Coming up next on the Jeff Crilley Show, we'll be talking to a state appellate court justice about why he's running for the Texas Supreme Court. That's just ahead.
Many are predicting that the worst is yet to come, which is unfortunate, said one person here. Until now, they've enjoyed the reputation of being the nation's icebox.
Watched a burglar in his home this morning by webcam.
As a journalist of over 25 years, stories are what make my world turn.
Reporting live from the Dallas newsroom tonight, Jeff Crilley, Fox 4 News.
But in 2008, I took the jump from my familiar life and started a PR firm from my home.
We're talking about anyone with a camcorder like the one I'm using becomes a television network.
We started slowly growing the company, and we now have over 100 clients, and we've branched into the world of live digital broadcasting. I now own 8 different TV studios and have a huge team, and the stories that I now get to share are sometimes the most important of my life. Life has a funny way of coming around full circle. This is the Jeff Crilley Show.
Well, from time to time, I like to interview people who are running for office, and in studio today, this has to be a Jeff Crilley Show first, a state appellate court justice. Thank you for coming into the studio, Justice David Schenck.
Thank you for having me, Jeff. I really appreciate being here with you.
Well, often people will read the name of a justice in the paper, but they don't really get to know him or her. Tell us more about your background.
Well, I grew up in upstate New York and in a family that was very active and busy. My father was a physicist and a medical doctor, went to college up there, and then came down to Texas as soon as I could in 1989 and went to Baylor Law School. I was privileged to graduate first in my law school class, much to my surprise, run the Law Review as editor-in-chief, and then left that school in Waco, which I loved very much, and went off to Washington, D.C. To work for a firm called Jones Day, where I worked in the issues and appeals practice, doing U.S. Supreme Court work, and then went back south to Louisiana and served as a law clerk to the chief judge of the Fifth Circuit Court of Appeals, which is the federal appellate court that sits over Texas and 2 other states.
Sure. And when were you named to the state appellate court?
I was appointed by Governor Perry in January of 2015, with my appointment actually then carried by Governor Abbott in the transition. There's an interesting constitutional provision that allows an outgoing governor to make an appointment, but the incoming governor has to carry it forward. So in a way, I'm appointed by both.
Well, before we talk about why you're running for Texas Supreme Court, what are some of the accomplishments that you've had at the appellate level?
Well, it's quite interesting. Well, I am board certified as an expert in civil appellate law. I've run the appellate practice at 3 firms actually throughout my 30-year career, including the Jones Day practice here. I'm a member of the American Law Institute. That's the body that drafts what we call the restatement of the state's laws. I've run a number of major appellate matters, including cases going to the U.S. Supreme Court, the IOLTA case, which provided the funding for legal services to the poor. We took that case to the U.S. Supreme Court. I received the State Bar's highest award for service for that. And I've represented Texas State Rifle Association and the U.S. Supreme Court in the Heller case, along with 40 other state associations. So there's a lot of work like that. I'm very proud of it. A lot of First Amendment work for religious liberty, things of that nature. And on my current court, it's been a wonderful experience for the first 7 years. I pushed hard on that court to pursue merits resolutions of cases. Quite often we'll have lawyers presenting cases to us in a rather imperfect way, and sometimes we had a practice of terminating the case without giving them a chance to fix it. I believe that was inappropriate. I've been pushing to fix that, and so far so good.
Awesome. Well, you've received some major endorsements, starting with the Houston Chronicle, and you also have the Dallas Morning News, so we'll put that up on the screen. That's got to feel good.
It does feel good. It makes me proud, and it's interesting in this case that as a challenger, although I'm the one with the judicial experience, but as a challenger, it's good to be recognized for my service to the court and the people of Texas on the bench. But what I find even more interesting is I've never seen a race like mine where you have big city newspapers like the Morning News and the Houston Chronicle endorsing, but at the same time, the grassroots conservative people like Texas Eagle Forum, Texas Right to Life, the True Texas Project, Grassroots America, all kinds of support. So it's coming from the grassroots and from the establishment. We're looking closely at the race.
Justice, why do people need to pay attention to this race? Why is this important?
Well, this is not your usual sleepy judicial race. The issues that I'm presenting are not just about the fact that I'm a real judge with a real record, or that I'm board certified as an expert in the only thing the Supreme Court does, which is civil appellate law. Both of those things are true. But I've also been pushing for the last 15 years for ethics reforms that the U.S. Supreme Court has recognized as essential to supporting the public confidence in what the courts do. Because ultimately, courts don't have the power over a budget. We don't have an army. The only reason that people accept what we tell them to do is because they have complete confidence that what we've told them to do is based only on our neutral and independent judgment about what the law is and what the facts are in any given case. And that has to be guarded rather jealously. And in my time on the bench, I've also been serving as commissioner, now the chairman of the Texas State Commission on Judicial Conduct. That is the body created by the Texas Constitution and responsible for the enforcement of the ethics rules as to all of the judges in the state, from the bottom to the very top. And I've seen the best in a judiciary, and I've seen not the best in a judiciary. But as I say, going back 15 years ago, when I was running the Texas Issues and Appeals practice at Jones Day, we had a very interesting case that came out of Minnesota, which I understand you're familiar with. And the whole of the federal judiciary in Minnesota and the appellate level was arguing over whether the states, in that case Minnesota, had the power under the First Amendment of the Constitution to cut back on the way judges raised money to run for office. And one of the things that they had pointed to in their disagreement with each other was the example that had been set by Texas. And unfortunately, Texas had at that time recently been the subject of a study entitled Pay per Play, which is on the web to this point, and a number of subjective pollings of citizens of Texas, lawyers and judges, all of whom overwhelmingly expressed the view that campaign contributions had an effect on the way cases were getting decided. That's a perception. The unfortunate thing was that the study also of the Texas Supreme Court looked at all of the cases that had been coming to the court and the court's decision whether to hear them or not. Now, the Texas Supreme Court doesn't have to hear any case. It has a discretionary docket. And so what those people had done was they went and looked at every petition that had been filed over a 4-year period, and then every campaign contribution that had been contributed over that period. And unfortunately, and no one knows the cause, and the point is you shouldn't have to look at the cause, we don't care. There was a direct linear correlation between the amounts contributed by the law firms and counsels appearing before the court and the court's decision whether to take the case. As we pointed out to the U.S. Supreme Court in our brief in that Minnesota case, there were 2 law firms in Texas who were contributing substantial amounts of money, more than $250,000 over the 4-year period of that study. They were 1,000% more probable to have their petitions accepted than non-contributors. And you would step it down all the way down to contributing nothing. That, as I say, there could be lots of reasons for that, but eventually the U.S. Supreme Court handed down a series of decisions, and it has now told the states 4 times that they can and they should amend their own rules governing when judges should step aside and recuse themselves so that the court and the judges are protected from the appearance. We don't get into what's actually operating in between the judge's ears when he makes a decision or she makes a decision. We just want to make sure that people don't have objectively reasonable questions about the relationship between support from an outside person and the outcomes in the court. And eventually, in one of those cases, the Supreme Court accepted the position we had advocated in that case coming out of Minnesota, and it said that states had the power because they have a compelling governmental interest in the confidence in their own courts to limit the way judges raise money. And what other states had done, and this is now 6 years since that opinion came out, is to pass ethics reforms that the courts themselves are responsible for. We have rules of civil procedure and we have ethics canons that the court itself writes. No one else can tell the court what those rules will look like. The ethics canons are what we enforce on the State Conduct Commission. The rules of civil procedure are what govern what lawyers do. What other states have done with respect to recusal, which the US Supreme Court said we should be looking at, is they have told the judge to step aside if you receive, for example, in Utah, more than $50 from a party or a lawyer who appears before you. That's a rather low limit. Other states have put it at $2,000 or $1,500 or $5,000. In Texas, unfortunately, we have not done that. We've left these limits at $25,000 per law firm, with more money potentially coming from lawyers within the law firm. And to make matters worse, we used to have an ethical restraint on judges who serve on the courts together, raising money together or spending it together. The US Supreme Court has also said we are to assume that judges are talking to each other behind closed doors to the extent that it affects public confidence in the decisions they make. So now Texas has removed that prohibition, and we're to assume that all the judges are presumably using the same pot of funds to participate in. I think that's remarkably unhelpful and going backwards, in fact, when we are now the state that has essentially done nothing to reduce this appearance concern. And to close the chapter on that, we had another case come to the Texas Supreme Court a few years ago where somebody was concerned about the possible connection between contributions and the result. This somebody happened to be a very wealthy Republican contributor from the Panhandle, and he had a team of statisticians available to him. So he ran the research for the next period of time, 10 years, and what it showed was, once again, there appeared, for whatever reason, to be a correlation between the amounts contributed and the court's decision to hear cases. Again, we don't know why that's true. It doesn't matter why it's true. What the Supreme Court, US Supreme Court, has told us in one of these four cases, a case called Caperton, is if there's a likelihood that financial support is affecting the decision, the federal Constitution won't suffer that. The judge has to recuse himself as a matter of federal law. But again, we should never even have to get that far to ask that question. The problem here is not why it's happening or what's happening, but it's an appearance concern. And that's really the heart of the problem. And I believe that Texas is overdue to address this. And I think the subjective data says that people are concerned about it. And the lack of action is what I think is most concerning and really is most overdue.
Integrity is such an important issue these days. I think there's a lot of skepticism out there. You're also not one of these guys that hides out in the ivory tower. You're out with the people. There's pictures on Facebook of you, almost like a who's who of Texas politics. Why is it important for a man in your position to be out there meeting people, hearing regular conversations of average Americans?
Well, I think this is part of the great debate about what's the best way to select judges. The argument for the appointed system, which is used in the federal system, is that the judges are secure from the concern about pleasing other people and are free to act as they want. Now, you will not see federal judges out and about shaking hands and doing things like that. The good thing about the elected system is it does require a more direct form of accountability. And ultimately, that's the question I'm trying to pose with this campaign is what kind of courts do we want in this state? And the people will ultimately get to decide that. And I think to decide that, they need to know who these people are that they're electing, and are they going to be accountable for their stewardship of these courts? And I think that's a good thing. And at the same time, this is part of what we argued in that US Supreme Court case, that the choice to democratically elect judges doesn't have to come with all the negative implications that comes from that decision, including how the judges raise money and how much they're raising and from whom. And my concerns are not just with the amounts that judges are raising, but with all kinds of obvious questions that would go with that. Like, what do you do about a judge who has a pending case, right? Can you give money to a judge if you're going to appear before him in the next week and make a decision. And other states have proposed, and this is another proposal that I've put forward, is that if you are going to give money to a judge while you have a case actively pending in front of him with an adversary on the other side, I think you should have to tell the adversary at that time that I'm making that contribution, because right now what's happening is you report that to a government agency in Austin maybe 6 months later. Somebody, if they exercise the initiative, might go and find that. But unless that happens, the only person who knows that the money changed hands between the lawyer or the litigant and the judge are those people. The other side is left in the dark, and that's an unnecessary, unwholesome concern that any litigant would have. So my suggestion is, why can't we just say, if we're going to allow lawyers and litigants to participate financially in a judge's campaign while they have an active matter pending, just list it, disclose it. If a judge and a party or a judge and a lawyer have a conversation in the hall room about something that happened in relation to the case, we consider that to be a very big deal.
Absolutely.
But the idea that a check has just changed hands for potentially thousands of dollars and the other side isn't aware of it is equally a big deal, and probably something the other side has a right to know about.
No, you're right, and we have to, as Texans, have faith in the judicial system. We've got about a minute left. What would you like to leave the viewer with?
Well, I think the critical thing for me and for this state is we're facing a lot of challenges these days, and ultimately, many of us believe that we need change, and this change starts with us. It's our government. It's accountable to us, and ultimately, if we want something better, if we want better times, it's up to us to insist on it. And I would ask people to get out and act. They can study my race, they can study other races. Ultimately, they need to vote, they need to participate in democracy, and whether it's good or bad, this government belongs to them. And if it's going to get better, it's going to be up to them to make it get better.
Wow. Justice David Schenck, thank you so much for coming into studio. We're going to end with your website, which is schenkfortexas.com. Thanks again for coming in.
Thank you so much for having me.
You bet. That's it for now. We'll see you next time.